I understand parties have been told that we are prepared to sit until 4:30 if necessary.
My Lord, the appellant is very grateful for that. In the time remaining, my intention is to address two issues: cumulative impact and the baseline studies.
Yep.
In order to provide factual background to that, it's necessary to have a look at what the finalised version of the TOR said and what the RAR, the review document, said. Neither is particularly long, and I hope I'm able to move through them both fairly swiftly. The first is in Volume 1. It contains both the draft and the final TOR, but they are in identical form. The final TOR starts at 154, and there we see a letter from the EMA to the Ministry, the second paragraph of which is worth noting. The terms of reference, which has been finalised and consists of 34 pages, is hereby submitted to you in accordance with Rule 5.3 of the rules. We saw those earlier. The EMA informs you that no technical changes were made to the draft TOR. And then over the page, under the introduction, the EMA has also determined that it's likely that significant environmental impacts will arise from the activity, which requires a CEC. As such, an EIA must be undertaken. EIAs must be undertaken in compliance with the terms of reference, which is prepared by the EMA in consultant with the applicant. Two things to note, here as elsewhere, very firm that you've got to live up to the requirements of the TOR. Second point is that there's nothing about the Arepo savannas. The fact that it's EIA is because of the risk of environmental harm generally and not solely because of its proximity to the Arepo savannas. And I raise that now because a point made against the appellant is that future phases move further and further away from the Arepo savannas and therefore oughtn't to be involved in the cumulative impact assessment. Moving on to page 157, the purpose of the EIA is to identify and assess the type and extent of environmental and socio-cultural impacts arising from the proposed project. The EIA must evaluate the cumulative impacts, note the mandatory nature of that, from this proposed project, ongoing projects and other proposed activities within the area and the surrounding environment. I'll turn in a few moments to the statutory and legal framework that imposes the requirement to undertake cumulative impact assessments. Again, a point made against us is that there's no definition of what a cumulative impact assessment actually is. But the case law provides a more than adequate definition, and we see in this document and in other documents that definition imported and agreed between the parties that it's what needed to be done. Below that, the applicant must ensure that details provided regarding the design, layout and operations of all activities are sufficient for cumulative impacts to be assessed and for a rigorous assessment of these impacts in the public domain. My lords, my lady, that's important because the onus is on the promoter, the developer, to ensure that there is sufficient detail to enable a meaningful cumulative impact assessment. We say there clearly is sufficient detail in this situation, but to the extent that there is any problem about the level of detail that exists, that is a problem of the applicant's own making because the onus is on the applicant to provide the necessary detail.
When it talks about this proposed project, what is that?
It's Package 1A.
Package 1A.
Package 1A forms one part of Phase 1.
Yes.
And the project overall that runs all the way to the coast, Manzanilla, the scheme as a whole is called the Churchill-Roosevelt Highway Extension to Manzanilla. What we're looking at within these proceedings is Package 1A only. It's a 5,000 metre stretch within the forest.
Yeah. I'm sorry, just when it says proposed project, ongoing projects and other proposed activities. So it's a sort of...
Future phases of most relevance.
But also other activities.
It could be other activities, but what we're concerned with here are phases. It's Package 2 of Phase 1, Phase 2 and Phase 3.
Yeah.
We'll look at a moment at the plans that have been put in, but just while we're on it, Package 1A is a 5,000 metre stretch that is unconnected to any highway. And that's made very clear in the documents and in the plans. I'll come back to that.
Well, at the western end, it's an extension of a highway.
No, there's a gap of a number of 100 metres, both at the west and at the east.
I see, very well.
And I'll make that point good in a moment. The EIA is intended to allow communities that can potentially be affected by the proposed project and the wider public to understand the project and its impact on them and their socio-cultural and physical environment, and to have their views and concerns addressed in the determination of a CEC application. So emphasis there on public participation, and similar emphasis over the page at point 7 of 158. Stakeholder consultation and public engagement, listing all the organisations and individuals consulted in the course of preparing the EIA report, together with the comments that they've made. Moving on to 160, outline of the EMA's understanding of the proposed project, the applicants applied for a CEC for the establishment of a new highway segment from Camuto to Sangre Grande. This proposed segment forms part of a larger proposal to establish a limited access freeway with dual lane configuration and provision for subsequent expansion when required. Further down, the alignment is proposed to traverse in a west to east direction, approximately 120 metres south of and parallel to the southern boundary of the Repo Savannas, commencing at a point, and here it is, my Lord Wilson raised this point a moment ago, commencing a point approximately 300 metres east of Camuto Road, so there's a gap there of 300 metres,
Yes.
and ending at a point 600 metres west of Guayco Trace, again, a further gap, and forest in between. Sangre Grande. The proposed scope of works does not include the construction of any bridges, interchanges, overpasses or underpasses, nor of any connections. And when we turn to the plans, perhaps it will be helpful if we do that now. We prefer the plans that we put in because they're just a bit clearer. And obviously the ones in the record of appeal are completely illegible. But my lords, my lady, I take you to three of these. They are all in the record of appeal, but the first is 835, and it's the first one in this clip. We see there the extent of package 1A, and it's described as package 1, it's green. Package 2 involves connection. It's the blue bit that you see to the west and also to the east. But this scheme is package 1A only.
So when it says package 1, that's wrong.
I think that's, that is the same as 1A. I'll have to check that. But there are... No, I think that's the total... My lord, I'll come back to you on that, if necessary, in reply. My lord, the next one is 838, which I think is the fourth of these, A3. Package 1, I believe package 1 is the same as package 1A.
Or can we call it package 1?
We can call it package 1.
Good.
And it's in green again, and it's a higher scale, so you can see there, without package 2, no connection. And then finally, there is, I think, proposed in the penultimate of these sheets, a construction access. I'll come back to that, but there is no way. The reason that the question of connection or road to nowhere has taken on prominence, we say subsidiary to the need for a cumulative impact assessment, whether or not it's a road to nowhere. The reason it's achieved prominence is that paragraph 95 of Mr. Justice Ramcharan's judgment says that if this were a road to nowhere, I would consider that this was arguable with reasonable prospects of success. So he put into very sharp relief the significance of establishing that it is a road to nowhere, which we say that it is. But whether or not it's a road to nowhere, we say that a cumulative impact assessment is necessary, and I'll turn to the legislation that shows that is, in my submission, right. It's the same as 1A. Yeah, I'm told that package 1 is the same as package 1A. So we were on 160. We'd looked at the description, no reference to any connection, and we're reminded in the paragraph, at the bottom paragraph, that we are talking about a road built into a forest reserve. Then over the page at 162, detailed requirements for the environmental impact assessment, and at 163, the description of the project. 3.3, to provide sufficient information on the scope and details of all phases of the project to allow quantitative assessment of the environmental impacts, and project scope below, description of all phases of the project, including but not limited to such and such. So there, the onus of the description on the developer. 170, moving on to...
Sorry, when it says all phases of the project, which project is that?
The project there, I understand to be, it's intended that it is the Churchill Roosevelt Highway extension to Manzanilla. So it is a multi-phased project.
The whole yes, it doesn't say that anywhere. I mean, I'm not disagreeing with it. It would be nice if it...
Well, it's just the word phases, because there aren't numerous phases for package 1. That is a single phase.
So you say that must be the whole thing?
That must be the whole thing. 170, biological environment, and these parts of the TOR are relevant to baseline studies. So I'm covering both baseline studies and cumulative impact assessment because it's more efficient to do so. The applicant shall use current, please note the word current, available information or site-specific field surveys to assess the receiving terrestrial and aquatic environments for impact prediction. Baseline studies are vitally important because they provide an indication of what it is that is being impacted. No proper understanding of impact can be achieved without baseline studies. And in a nutshell,
Sorry to be so ignorant, what is a baseline
a baseline study is an assessment of what is already there. So if you find protected species, if you find lots of ocelots, if you find flora and fauna that contribute to the designation, then you note that, and against that background, you consider what the impact of the introduction of a highway might be.
Very well, thank you.
Without establishing that, it's impossible to assess impact. And that, in a nutshell, is the reason why you cannot hive off those issues to conditions. They have to be done at the outset. There are matters that can be hived off to conditions, that can be deferred, but there are other more fundamental matters, and baseline studies is a quintessential example of that, that need to be done in advance. At 171, characterisation of the biological environment shall include, but not be limited to, and then baseline studies relating to flora and fauna. I move on then to, there's a reference to stakeholder consultation at 174, but moving swiftly on to cumulative impacts. That's at 178, analysis of environmental impacts, and 8.3, the description of impacts shall include an assessment of the cumulative environmental impacts that are likely to result from the proposed activities in combination with existing, approved and proposed projects. Those are the words that are used in the judgments that we'll turn to in a moment, but they give description to the word cumulative impact in the legislation, in the area that could reasonably be considered to have a combined effect. And 8.4, second sentence, cumulative impact shall either be described within a specific section of the EIA report or be well defined within each of the report subsections on potential impacts as relevant. They shall not, it says here, be hived off to conditions. I mentioned earlier that this TOR was the subject of agreement between the EMA and the Ministry did not seek to make any modifications to it. The final reference...
Sorry, where does it say there shall not be hived off conditions?
My Lord, that was my submission. There's no indication that that matter can be deferred until conditions. Before we move on to the RAR, which occurred about 6 months later and identifies the errors or the deficiencies in the EIA that was conducted, I just pick up on one final point because it's in our written case. We don't abandon it, but I'm not going to spend time on it today. 187 proposed buffer zones, and my learned friend Mr. Ramlogan has indicated that there was, according to the Canary report, a recommendation that there be a 500-metre buffer between any development and the Arepa savannas. The result of the CEC that was granted is a much shorter buffer of a little over 100 metres, and that we find at 187 of the TOR. Let's pick up, if we may now, the RAR. So the TOR is dated December, my Lord, I'm grateful. December the 12th, 2016. We then move to the RAR, May 22nd, 2017, shortly before the grant of the CEC. And we see there, having reviewed the EIA that was...
Where is this?
This is, I beg your pardon, my Lord, it's volume 3 and it's at page 850. The EMA has read the EIA, the second EIA. I'll pause for a moment. But not longer than a moment. Page 850 is the beginning of the RAR. This is a mechanism by which the EMA indicates to the developer, in this case the Ministry, whether or not what it has provided in the EIA conforms with the requirements. Second paragraph says, the review of the EIA identified several deficiencies which must be addressed to enable... Page 850, my Lord.
Thank you. 22nd of May.
22nd of May,
and
shortly
this is
before...
from the EMA.
It's from the EMA to the Ministry. It results from a consideration of the content of EIA 2.
And this is Mr. Romano, the person who eventually signed it off.
It is. And at this time, Mr. Romano is insistent that the requirements of the TOR be adhered to. Yeah. The second paragraph says, the review of the EIA identified several deficiencies which must be addressed to enable informed, objective and fair decision-making with respect to the granting of the CEC. Please be guided by the findings of the attached review and assessment of the RAR. However, please note that this RAR is not exhaustive and the EMA reserves the right to request further information on additional issues that may arise during the review process. And the bottom paragraph says, pursuant to Rule 6.2 of the CEC rules, the EMA hereby notifies you that we are unable to make a determination of your application at this time, and can only do so when the issues highlighted in the attached RAR are properly addressed. My lords, my lady, that is important, because there is a mechanism within the legislation by which the EMA can decline to determine. It can either grant a CEC, it can refuse a CEC, or it can do neither and seek further information. The RAR seeks further information. And that further information appears for the first time in the third EIA, published 2 months after...
You say that's in the statute?
That's on the statute. I'll come to it in a moment.
We haven't got time to look at the attachment, then. Well, the RAR itself.
We need to look at it, my lord.
We do.
I'm afraid we do.
What's it say about the cumulative point?
It says you've got to do it.
Where is it? Where does it say that?
Baseline studies at 859, cumulative... 870, sections 6.3 and 8, it's hard to read, and 8.4 of the final TOR required an assessment of cumulative impacts. Page 110 of the EIA report identified potential cumulative impacts in relation to other segments of the proposed. However, no assessment, discussion or analysis was submitted in support of this table. Furthermore, at page 152, cumulative impacts were considered to be not applicable. The project is package one of a larger project to establish an alternative route from the end of Churchill-Roosevelt Highway. My Lord has the page.
Yes, I do.
Please revisit this statement, as well as the overall assessment of cumulative impacts. So that's what it says about cumulative. It also has a lot to say about baseline studies, and we're dealing with them together. It's worth looking at 852 and 853, where it makes emphatic that without these deficiencies being repaired or addressed...
852.
852 and 853.
Going back.
I'm going back, just because there were references there that I wished your lordships and your ladyship to have. 853 in particular, these aspects are considered critical for the assessment and the decision-making process of the EMA. My lords, the appellant contends that it was irrational to grant a CEC in the circumstances that prevailed here. The appellant understands what a high hurdle that is, but what we have here is the background that is relevant to an irrational decision, because there is a continual insistence on the requirement to meet the standards of the TOR and then a sudden abandonment of them at the last minute. The next paragraph, the Ministry of Works and Transport or its designated representative must address these deficiencies in writing to the satisfaction of the EMA. It's a non-negotiable. They must be addressed. This is necessary to facilitate the EMA's ability to make an informed decision on the relevant impacts of the proposed project on the human and natural environment. That too is relevant to irrationality, because without that being done, an informed decision is impossible. The deficiencies are then listed out. And it makes clear below that the decision to grant or refuse the CEC will be informed by a satisfactory response to the issues identified below. So we looked at cumulative impact. There's also a lot of material within this document on baseline studies. 859 is where it starts. 858, description of the environmental and social cultural characteristics of the study area. Above, at the top of 859, section 5.1 of the final TOR required the applicant to conduct a review of recent studies. That's important, my lords, my lady, because the interested party relies on 2006 studies, and in defence of that position contends that there hasn't been human intervention within the relevant land. My lords, my lady posed a question to my learned friend Mr. Ramlogan in relation to Rule 5. What use would it have been? Why was it appropriate to consult members of the public or NGOs such as Fishermen and Friends of the Sea? Well, there's an example of why it might have been useful, because it's contended that there had been no human intervention. But by consulting locals, by consulting NGOs that are concerned with the environment, it might be possible to make good that contention. The appellant does not agree with that and does not therefore agree with the basis upon which the requirement of baseline studies was abandoned against the background of 2006 studies. Those are studies that relate to both flora and fauna. The respondent and interested party do rely on more recent studies, albeit that they only relate to flowers. And here we see in detail the objection. At 860, the rationale for utilising the 2006 sampling at 3, first bullet, in the description of the baseline environment is not acceptable. And that's repeated. So we have here, I won't go into more, 870, analysis of environmental impacts is an important section. The first paragraph deals with baseline studies, the second with cumulative impacts. So that's the background that's relevant to both cumulative impact and baseline studies. The relevant provisions of law are set out in the appellant's case, which your lordships, your ladyship will find at volume 13, 5, or if it's loose, as I see it is for some of your lordships and perhaps your ladyship, you'll have it there. But it's paragraph...
Starts at paragraph 107, I think.
Beg your pardon, my lord.
Starts at paragraph 107.
107. Thank you, my lord. So the provisions of law, Rule 10, this may be familiar to your lordships and your ladyship now. It's a combination of Rule 10 and 2 that requires a cumulative impact assessment to be made. What does that mean? Well, we know what it means. It requires taking a hard look, according to Mr. Justice, Mrs. Justice? Mr. Justice? Mrs. Justice Stolmeyer. A hard look requires the agency to take its responsibilities seriously. It must, over the page, include an analysis of the cumulative impacts of past, present and future projects. And that is the highlighted section at the bottom of that dictum. There is then a summary provided by, again, I think Mrs. Justice Dean Armourer, in the pure case at 113, and that appears at the top of electronic bundle page 5608, but in any event it's above paragraph 112 of the appellant's case. And there is there a summary of the requirements in terms of cumulative impact assessment. Happily, in this case, the respondent accepts that a cumulative impact assessment was not conducted. Well, I hear disagreement there, so I'll go to the exception.
I'll mention, yeah, I'll come to a qualification.
I'm grateful for that disagreeing noise. I will therefore go to the place at which it's accepted. It's 12-5641-56. Or if you have it loose, this is the respondent's case. '56 says, it is accepted that the revised EIA, and there the revised EIA is a reference to the second rather than the third EIA, did not contain a specific cumulative impact assessment on the 5 kilometres in question when taken together with the rest of the proposed 32-kilometre highway. And then it says it contained cumulative impact assessments on other matters, but not that one. It's clear, as we've seen, that the TOR required a cumulative impact assessment. A number of explanations are given for its absence. And they are these. The wording of Rule 10, may, the use of the word may, is entirely permissive. And that we find at paragraph 62.1 of the respondent's written case. The question that must be posed then is, why did the EMA see fit to require or insist on one? And why did the Ministry proceed on the basis that one would be provided, or else query this rather than agree to it at the TOR stage? The next point that is said by way of explanation for its absence is that cumulative effects are not defined, but the case law gives us an ample definition, and that definition finds its way into the TOR and the RAR without contradiction by the Ministry. The third one is that the EMA was entitled to drop the requirement for a CIA when the Ministry said one would not be practicable because of a lack of detail as to further phases. I'll come on to that detail in a moment. This raises the question of rationality of so doing, especially when there is nothing in the justification by the Ministry. And finally, the road to nowhere. This point is laboured by both the respondent and the interested party, and it is in any event wrong on the facts. In effect, the EMA misunderstands the use of the future tense. It reads for will be provided as part of package 1. In fact, will be provided is in later stages of the overall scheme, each one of which will need to be the subject of a CEC application, which may or may not be granted in due course. From that list, 2 points can be shown to be baseless on the available evidence. The first is that there was insufficient detail to enable a cumulative impact assessment. And the second is that package 1 was not a road to nowhere. So the available detail is provided to some extent in the appellant's case, paragraphs 118 to 123, which deals with both issues, baseline studies and cumulative impact. But we have...
I'm going to stop for a moment. Package 1, you say, is not a road to nowhere. But if you take package 1 and package 2 together, then it isn't a road to nowhere. Is that right?
I think that's right.
Yes. So, the judge may have been approaching it on the basis that at least there was an assessment of package 1 and package 2.
Well, let's see what the judge says then. Ramcharan's judgment is at... Mr. Justice Ramcharan's judgment is at...
It's in volume 10, page
10.
4785.
Yeah, volume 10, it's 59, page 4814. If it were that phase 1, phase 1 could not have been...
Where are we reading now?
4814.
Paragraph number, please. I'm working
59.
A different copy of it.
I beg your pardon. It's 59 of the judgment.
59, thank you.
If it were that phase 1 could not have been considered a standalone project within itself, I would have been disposed towards finding that there was an arguable ground with a realistic prospect of success. In other words, if it were that the construction of phase 1 would not make sense without the construction of any of the future phases, then it would clearly be irrational for the EMA to grant a CEC without considering the effects of other phases upon which usability of phase 1 is dependent. And then Mr. Justice Ramcharan provides an illustration. In the example given to Senior Counsel for FFOS, if there were a project to build a causeway and phase 1 carried it to the middle of the Gulf of Paria, then clearly it would make no sense for the EMA to grant a CEC for phase 1 unless it understood the effects of phase 2. A causeway to the middle of the Gulf of Paria does no one any good. On the other hand, if phase 1 in our hypothetical situation ended in Port of Spain, then a CEC could be granted without consideration of the effects of phase 2, because phase 2 is for all material purposes independent of phase 1. It's in effect a causeway from Port of Spain to Port of Pia. 2 points, my lords, my lady. One is that there's no suggestion here that a construction access would be sufficient to deal with the issue. It must be a normal connection to the road network, such as to enable it to be used. But the second point is it's very clear here that Mr. Justice Ramcharan, had he been aware that he's only dealing with phase 1, that's made very clear from this part of the judgment, and were it not for that misunderstanding of the factual position, he would have found that there was an arguable case with realistic prospects of success. My Lord Lloyd-Jones, I think, perhaps that was a previous reference, but again, I'm scrambling to find the reference in our own written case to the beginning of the available detail, which is at paragraphs 118 to 123, and here it is.
Sorry, of what are we on now?
The appellant's written case, where it starts, as for the details of the other phases of the CRHE scheme, there is no shortage of these. And then some of those details are set out. But we find other important details in the notes of the consultations that were conducted in relation to the first and the second EIA. This is volume 7. If you, my lords, my lady, could pick up volume 7, 3152.
You appreciate, Mr. Wald, you're now eating into your reply time.
I do. 3152, my lord. There are... Now, one of the criticisms in the RAR is that the notes, the minutes of the consultations that were conducted in respect of EIA 1 and 2 were not published. We understand them to have been published later on. They appear here as an appendix to an affidavit. But the critical thing for present purposes is that they give a very candid view from NIDCO, the company established on behalf of the government as a delivery vehicle, in answering questions about the connectivity and the detail available about the various phases.
Can you give me the page again?
Yes, it starts at 3153.7, and here's an example of it.
3157.
3153 is where it starts, or 3152.
Which volume?
It's volume 7, my lord. Project manager distinguished between package 1 and package 2. Package 1 illustrated on map as south of Arepo Savannas. And then I turn over the page to a question put by a resident, Omati Juan Ramdas, page 3155. Do you have any timelines? The designs are completed and accepted. How old are they? And the answer given by NIDCO. Designs are completed for the most part in 2007. Phase 1, first 14 kilometres, is the only stretch that is 100% completed with road network, drainage, lighting, etc. Construction timeline is 30 months to 3 years. Now that is why I thought we're going to need to clarify this point. Phase 1 is described as 14 kilometres long. Package 1A, or package 1 of phase 1, is only 5,000 metres. So phase 1 in its entirety is almost 3 times as long. And it's approximately half as long as the whole development scheme, which runs to just shy of 30 kilometres. So here we have NIDCO saying that at the very least, there is total detail up to 14 kilometres. So a cumulative impact assessment could be conducted in respect to phase 1, the other parts of phase 1. But that didn't happen.
You're saying that the judge made a basic mistake on this point. Was this point taken in the Court of Appeal?
I'm told it was. I was told it was, but it's certainly been flagged throughout. And my Lord, while I'm facing that question, it's similar to a question that my Lord Carnwath posed earlier. The point about EIAs 2 and 3 was raised in front of Mr. Justice Ramcharan. It was brought to my attention because, if you got it.
Well, never mind. I mean, carry on. You make your point. But
It rather looks from paragraph 6 of his judgment as if he understood that there was an existing highway which was being extended.
Well, there is an existing highway.
There is an existing highway, but the 5,000 metre stretch does not result in an extension. It is a stretch within forest, unconnected. It would eventually become an extension.
Where is the clearest description of what there is and is going to be? Or is this it here?
I'm afraid, well, there is, the CEC application contains a description, and it describes the 5,000 metre stretch as 300 metres to the east and 600 metres to the west, shy of existing roads. And in our submission, that is, if you'll forgive the pun, the beginning and the end of it, because it doesn't indicate any connection to an existing road. But there are various descriptions here, and, well, I'll find a better description.
Right. Well, don't worry now. I mean, I should carry on because you've only got another 5 minutes or so.
This was a point raised by the appellant, and this is 4927, page 4927, which is volume 10, I think.
Yes.
I see 93. Yeah, we've got that. Okay.
My Lord Carnwath has found it.
Well, it's paragraph 93 or something. The appellant contends that the trial judge was plainly wrong in his finding the project was standalone.
It was raised.
So that's a lot of other points for raised.
My Lord, I want to leave a little bit of time for reply, so I'm going to turn to baseline studies. it may be that we have dealt with those in sufficient detail. We do rely on the internal memo, where the third manuscript entry of which is by the relevant legal officer, and in a way summarises the principles that arise from the case law such as Smith. That principle is that there are some conditions that simply cannot be hived off to a later stage. Where's the internal memo? So it's difficult to read, and that's the reason it's set out in full in the appendix.
I mean, it's an obvious point you're making. That
Yes,
you
it
can't
is.
assess the impact of something unless
It
you know
is
what's
an
there
obvious
already.
point. I won't labour it.
Doesn't require a great deal of-
My Lords, I think, unless there are questions on those submissions, I will save myself a little bit of time in reply.
Yes, very well then. Thank you very much, Mr. Ward. Mr. Knox.
My Lords, I just make a fundamental submission right at the beginning. We say one must focus on how this case was put to the judge. And there is, in my submission, no basis for criticising the judge, given how the case was put to him on the material issues. And therefore, the Court of Appeal was correct to dismiss the appeal, and in my submission, so should you. And if I could just summarise very briefly, it more or less follows what I say in our written case. First of all, we say the courts below correctly construed Section 11 of the Judicial Review Act and found there was no good reason to extend time. And I say there is no basis for interfering with those assessments, or that assessment, especially as, first, there was no application to extend time below. First instance, no application as such, no written application, or indeed evidence addressed to the point on either side. Secondly, this is public interest litigation involving no private rights. And I submit, as you will have seen in our case, that does require a rather more stringent approach to questions of time, or can at least. Secondly, on Rule 5.2 of the rules, if I can call it that, the courts below, we say, were plainly right to say there was no breach of Rule 5.2 on the facts. There is no answer to the question put to my learned friend, what is the meaning of where appropriate in the relevant rule? But further, we also add a claim based on breach of the rules is far too late. The final tour was agreed on the 12th of December 2016, and it was put on the National Register, I think, on the 20th of December 2016. And we say that was, properly speaking, a final decision, not a provisional decision. And it follows that the time for challenging that decision ran from December 2016. And it's far too late, after all that has happened since then, for that decision to be reviewed, even if it were wrong, which we say it isn't. Thirdly, the courts below were correct to hold that the authority, the Environment Authority, did not act irrationally or unlawfully, and that, we say, is the test, in dispensing with a cumulative impact assessment of the 5 kilometres in question, together with the rest of the proposed 27 kilometres of the road. Further, we submit that Mr. Justice Ramcharan, so far as the point matters, was entitled to find that this was not, quote, a road to nowhere. Fourthly, we say there was no illegality in granting the certificate subject to conditions. That's obvious in one sense, but in particular, we say, the revised impact assessment or environmental impact assessment was good enough to justify such a grant. So one can forget all about the final one. The revised impact assessment was a perfectly proper document to form the basis of a grant. And we say no proper case has been advanced to explain why not. I shall develop this point later. So I say the crucial question is, was the revised impact assessment, which was prepared in February 2017, was that a document which could justify the subsequent grant of the certificate subject to conditions? And we say manifestly it was. And apart from that, there was nothing unlawful in any other respect in granting the certificate subject to conditions. My Lords, I will be dealing with the substance of the respondent's case, but Mr. Benjamin will deal with the question of prejudice, specific question of prejudice from the Ministry's point of view, in relation to the question of delay, and one or two other miscellaneous matters about how the case was presented below and so forth. My Lords, can I just make one preliminary point, and it's one of the points we take in our case, and that is precisely what approach should you take to this case. Now, we say, in reality, the whole point of this litigation, bearing in mind it's public interest litigation, is to seek an injunction to stop the building of the road. It would be an entirely academic and futile exercise if, let us say, your lordships were not prepared to grant an injunction, but nonetheless say, well, I suppose you might just have a case that may go to judicial review. And I submit it would be fundamentally unfair on the respondent to say, well, look, you can go ahead, notwithstanding the ruling that there is a case. I submit that bearing in the light of the facts of this case, the proper approach would be to look at the reality of the situation, and first of all to decide such points of law as can be decided on the papers at the moment, rather than defer it on the basis, well, who knows, some other court might take a different view. I submit you should decide such points of law as can properly be decided now. And secondly, I do say, as part of the same submission, you should form a view as to really whether or not any of the grounds in question has a realistic prospect or a good prospect of success. In other words, because in reality you're being asked to grant an interlocutory injunction, or at least we're going to be put in a position where we cannot carry out the works in the meantime, I submit it would not be right to give leave on the basis that there's no injunction, but nonetheless my clients can't do anything in the meantime, which comes to just the same thing as there being an injunction in place.
And there's no suggestion here that an undertaking of damages is the right remedy. It's simply a question of what the public interest requires.
And we have no undertaking in damages anyway. And that matters, of course, not so much to me, although it would be a thundering bore to go through the process all over again, but also, of course, to the Ministry, but also there is the other interested party, Calco, who was in the Court of Appeal. But I do submit that certainly the right approach would be to bear in mind the reality of the situation in this case, bearing in mind we have a public interest litigation. Is it really right? Because what my learned friend seeks to do is, so to speak, get his foot in the door by saying, aha, I've got a realistic prospect of success on the judicial review claim, on the merits. You don't have to take matters any further. But then sort of later, I might be able to get an injunction somewhere or other in support of it.
But the truth of the matter is you've got competing public interests. You've got the public interest in protecting the environment and this particular important piece of the environment, and we've got the public interest in a major public project which is of importance to the economy going ahead if it's lawful.
Of course, my lords, I accept that, yes. It's, I suppose, really a question of exactly what the right approach
yes, what I'm saying is some of the cases we've been cited are cases where there's a purely private interest on one side in not being extradited or something like that, whereas here we've got very strong competing public interests on both sides.
Indeed, my lord, yes. My lords, you will be familiar, no doubt, with the Bakongo, the first of the Bakongo cases, which deals with the question of interlocutory injunctions. And can I just very briefly take you through that? Because one of the relevant factors is indeed, certainly if one approaches it from that angle, one of the questions you should take into account is indeed the strength, or otherwise, of the case. And one can see that at volume 13 of the
So, are you accepting that the strength or otherwise of the case is a matter to be weighed under 11.1, good reason?
No, I would accept that as well. I'm slightly jumping ahead. But let's say, for instance, this was a very strong case and an outrageous breach of the rules, let's say by my client. Then obviously that is a good reason. That can constitute a good reason. I would accept the strength of the case and the importance of the wrongdoing would obviously constitute a good reason. I would accept that. So if your lordships were satisfied that, let's say, there's grotesque behaviour by my clients, well, I would accept that is something to throw into the balance. But, of course, subject, of course, to how the case was put before the judge. But But as a matter of principle, I would accept a good reason can be the strength of the case, the importance of the rights which the individual needs to protect. But of course, here we're not in that territory, it's the public interest. And so
Yes.
My Lords, just on the question of the proper approach, when in reality an applicant is seeking an interlocutory injunction but won't be able to pay, Congo number 1, you can find at volume 13, and there's an appeal from Belize, and it's at tab 10, and it begins at page 5863. And this was a similar case.
We haven't got tabs, I think.
Sorry?
We haven't got tabs.
Oh, 5863. I thought perhaps I'd just been, the respondent had been put in a different position. 5863 is where the case begins.
Yes.
But the relevant, and essentially this was a claim for an interlocutory injunction to restrain the continued building of a dam by a public interest group, and the problem was they couldn't give an undertaking in damages. And so you can see how the point is put. First of all, at 5879. The relevant passage begins at 5878, injunctions in public law cases. I don't propose to read all that, but this is where it starts. And then the conclusion, after an analysis of some previous cases, is at paragraph 39. Both sides rightly submitted that because of the range of public law cases is so wide, the court has a wide discretion to take the course which seems most likely to produce a just result, or to put the matter less ambitiously, to minimise the risk of an unjust result. In the context, Mr. Clayton referred to Allen and Jambo, which has had the result in England of a very large class of litigants who are, as a matter of course, accepted from the need to give the cross undertaking in damages. However, their lordships, without casting any doubt on the practice initiated by that case, do not think it can be taken too far. The court is never exempted from the duty to do its best on interlocutory applications with far-reaching financial implications to minimise the risk of injustice. And then there's a reference back to Lord Denning's judgment in Jambo. And then moving on to paragraph 44, Mr. Clayton submitted that Bakongo has a strong case on appeal. He relied in particular on certain regulation. Mr. Fitzgerald described Bakongo's case as risible. Their lordships don't accept it as risible. This is a matter of great public concern, involving, as it does, between two very important public interests. But despite the skill with which Mr. Clayton developed his case in the limited time available, it doesn't appear to their lordships to be a strong case on which to seek, without an undertaking in damages, an injunction which would halt a major construction. And in my submission, we say that gives the indication that one of the factors you have to take into account on an interlocutory application like this is indeed the strength of the case. And that, I submit, will be in line with the approach which you find more generally in other types of cases. We refer in our written case to the Privy Council's decision in National Bank of Jamaica, a decision of the board where, again, it was said in terms, and I can give you the reference, it's volume 14, page 6133, paragraph 17 to 18, which is 6137, which says in terms that where you're dealing with an interlocutory injunction and someone's not able to give an undertaking in damages, well, then you should take into account, or one of the things you're entitled to take into account is the strength or otherwise of the applicant's case, because that goes to the balance. So that's what we say. We say you should, A, decide such points of law as you can, properly count the papers. B, you should, too, look at the real strength or otherwise of this case. And we say if you do that, there can be no doubt what the result is. Can I now deal with the delay point? The law, my lords, you've seen, if I can just go back to that in volume 13 at page 5729, you'll note one point which I may as well mention it now, right at the beginning, 5729. You'll see when this Act came into force, because I want to come back to this later in discussing what is the meaning to be attached to Rule 56.5. you'll see this Act comes into force in November 2000, having been assented to in October 2000. The relevant sections, first of all, I ought to draw your attention to section 6.1. No application shall be made unless leave has been obtained in accordance with the rules of the court. I'll come back to that phrase later. And then section 7.1 provides for applications in the public interest. Where the court is satisfied that an application for judicial review is justifiable in the public interest, it may, in accordance with this section, grant leave. And then subsection 7 over the page, 5732, the things that are to be considered in an application which seeks to vindicate the public interest. And you'll see 7A, B, C, D, E, and F. One then goes to section 10, which provides for interlocutory orders, applications rather, and orders. And then section 11, my lords, you've already looked at that a few times. And my lords, we say there cannot be any doubt that the proper construction of it is that section 11.1 is a self-standing section. And if you want to get yourself, as it were, if you want to get round the point that you haven't come promptly, or at least within the 3-month period, there must be, quote, good reason for extending the period. Now, good reason is not defined, and I fully accept that there can be a number of things that constitute good reason, the sort of things I've mentioned earlier. I would accept, too, that at least taken together with other matters, if, let's say, there is no prejudice whatsoever to the respondent, but let's say a very strong case indeed, one might well say, well, there seems to me good reason taking those two things together. But mere delay, mere absence of prejudice from delay, I submit, will not of itself be a good reason. That would, in my submission, fly in the face of section 11.1. And section 11.2, in my submission, is really simply saying, providing that even if you have a good reason for extending time, you can still be refused leave. That, in my submission, is the proper construction. And indeed, even if you come within 3 months, you can still be refused leave. And indeed...
I didn't quite follow that. Even if you have a good reason within
yes.
1, 2 is dealing with if there's been undue delay. So,
yes.
I mean, how can you have a good reason for an extension
well,
and yet be guilty of undue delay?
Well, you might, for instance, come one day after 3 months. You may have a very strong case indeed, but supposing, for instance, I agree with the undue delay point, but supposing, for instance, there's no substantial... Supposing, however, you've got a very good reason, let's say, for an extension, but there will be substantial prejudice to the rights of the third party. So supposing in this case, we'll take a different case, someone comes along after 3.5 months with a very good case. On the other hand, there's going to be very substantial prejudice to a developer or what have you. In those circumstances, I submit 11.2 would qualify 11.1.
I mean, in your case, you made a suggestion that had a certain amount of superficial attraction, and that was that 2 was really dealing with when, with a situation you were within 3 months,
yes,
but you still weren't prompt.
Exactly. Well, my lords, I submit
And
that's the primary purpose.
That may be arguable.
Yes. Well, my lords, that's my primary position. But I submit one can take it further. But I may not need to take it further on the facts of this case. On the facts of this case, all I need to say is you haven't got a good reason in the first place because there's no good reason to extend time. That's my simple answer.
I mean, the judge's decision was simply to refuse an extension.
Yes.
And the consequence of that was that the application fell.
Yes. Exactly. My lords, obviously the two can overlap in certain circumstances. As a matter of fact, you can. If I have a good reason, but perhaps I can simplify it. If I come within section 11.1, then I can still lose because of section 11.2. So and the classic example would be, I bring my claim, let's say, within 3 months, but nonetheless it's substantially prejudiced the third party's rights. And in those circumstances, I submit I would be vulnerable under section 11.2.
Can you tell me on something which I've always found a mystery? Prejudice to the public interest, is that a factor? And it talks out to a third party, or to good administration. But I mean, the public interest in getting a much-needed road built, is prejudice to that a relevant factor?
Well, it might come into sub-paragraph 2, would be detrimental to good administration.
Yes, I mean, there has been some authority on it, but I've always found it a bit of a mystery that it's put quite as narrow as that.
Well, my lords, what this all appears to go back to was there had been a reverse position in England where there had been the Supreme Court Act and I think the old rule, Order 53, which appeared to say different things, and eventually they got resolved in Caswell, which more or less resolves the situation, the position along the lines you see in section 11.1 and 2. And clearly the draftsman had to look at Caswell to come up with this form of drafting. I can take you to that, but my lords, that's the history behind it. But the reality is you just have to look at the words themselves.
Yes. But I mean, your submission would be that significant detriment to the public interest would be a relevant factor if you get to that point. Yes,
certainly. And I accept the phrase public interest isn't used, but detrimental to good administration, I submit, would cover it. My lords, Rule 56.5, you find at 5774 in the same bundle. Sorry. 5774. This, I accept, my lords, doesn't appear to say exactly the same thing. It's worded differently on any footing. It appears to make delay rather than... Well, it doesn't have what you might call section 11.1. Now, my fundamental submission is that cannot affect at all the construction to give to section 11.1. My lords, what I would like to do is just explain how this apparent conflict, if there is one, came about, and why, therefore, you should take no notice of it, and why you should construe section 11.1, so to speak, without reference to Rule 56.5. If you go to, there's a bundle of supplemental authorities, which was what my learned friend referred to. I don't know if it's on your lordships. Maybe it is. If I can just take you through what happened chronologically to see how this section, how these rules came into force.
Is this a point that's going to come up in the Maharaj?
Sorry?
Is this a point that's going to come up in October?
Well, it might do. I'm not sure they're putting it quite like this, but yeah, according to Mr. Ramanogan, yes. But in my submission, it's come up now, and it must be dealt with now. And my lords, because I am anxious to scotch the point that section 11.1 is somehow watered down by section 11.2. If you go to...
Funnily enough, you've shown us section 6 of the Act. No application for judicial review shall be made unless leave of the court has been obtained in accordance with rules.
But which rules?
Yet you are, fully understandably, inviting us to ignore the rules.
On questions of time. Because, of course, there are plenty of other rules. But, my lords, if I can just explain, first of all, what the sequence was. How did all this come about? If you look, first of all, at tab, I think it's...
I'm sorry to interrupt you, Mr. Knox, but while we still have the rules in front of us, do we have anywhere Rule 56.3?
I'm not sure if we do.
Because that's the one that the judge relied on. It's to do with applications for extensions of time. and the need for affidavit evidence to
yes,
support the application.
We don't have that, my lords, that is right, he does, and my lords, I don't think it's contentious that the application, there was no application, and the rules require an application supported by affidavit evidence.
Yes, it's rather important.
My lord, yes. Yes.
Yeah.
Well, they proceeded on the basis they were in time, didn't they? Their evidence for each
But
of the cases.
they were plainly wrong on that. Can I just explain what happened, and you'll see what my submission is. If you go to tab 1 of the supplemental bundle,
Yes.
you can see Legal Notice 27, and these are the Supreme Court Amendment number 3 rules made in 1982, which effectively mirrored rules, the Order 53, which had recently been passed in England. If you go to over the page to Rule 4, you can see the rule that was in force as from 1983 onwards. It's 4.2 is what really matters. Now, in 1988, the civil procedure rules were passed, and those are the rules which contain 56.5, but they were not brought into effect. And you can see that. If you go to tab 3, you can see what was meant to happen, but didn't happen. If you go to tab 3, you'll see the appointment of the operative date for the civil proceedings rules. And you'll see in the preamble that they were meant to be brought into effect in 1999, or on a date after 1999, to be fixed by the Rules Committee. That's in the preamble after the main heading. But in fact, they were not brought into effect until the 16th of September 2005. So one asks, well, what happened before then? And what was going on before then? Well, the answer is that in 2000, the Judicial Review Act was passed. I've shown you the references in October and November. And in my submission, the effect of that was that Section 11 of the Judicial Review Act entirely overrode what was previously in the rules of Supreme Court in the 1982 version. In other words, the Act now took prominence in the event of any conflict. After that, in 2002, if you go to tab 2, and still before the civil procedure rules were brought into force, you'll see that the Rules Committee did make rules pursuant to section, and this is tab 2, pursuant to section 878 of the Supreme Court of Judicature Act, and pursuant to section 24 of the Judicial Review Act, which I'll come back to in a moment. Now, the interesting thing, but what one knows... Hope springs eternal.
Relative.
Yes, nothing like a transitional provision, but if one looks at this, the draftsmen are consciously not bringing into effect. They are bringing into effect, as were all the usual procedural rules for how you make an application, but they are not bringing into effect any time provisions. And I submit the reason is obvious, because Section 11 of the Judicial Review Act already covers time.
So where is that? It's tab 2.
It's in tab 2. So we're still, so to speak, under the non-CPR regime. Someone says to himself, right, we need to pass some rules to give effect to the Judicial Review Act. And I'll come back to Section 24 in a moment. And so what they do is they pass these rules, Order 53, which set out standard form rules as to how you make applications for judicial review. About the affidavits, statements, documents, nature of the evidence, and so forth. But I think I'm right in saying there is no provision as to the time when you do it. And obviously, that is right in my submission, because if you go back to section 24 of the Act, which these rules are made under, and that's at volume 13, the Rules Committee established under section 77 of the Act may make rules to give effect to this Act. So the only thing the Rules Committee can do is give effect to section 11. You see how I put it, my lords. They can't alter it at all. And I submit, nor do they in 2002, when you still have the old regime in force, if I can put it that way. But what then happens is, if one goes back to tab 3, which I took you to earlier, in 2000, so in other words, if I can put it this way, there's complete clarity between 2002 and 2005. Section 11 is on its own. There's no other conflicting or potentially conflicting time provision in the rules. And I submit that's manifestly what is intended and should be the case. However, in 2005, going back to tab 3, you get the rules, the civil procedure rules, brought into force as a whole. And obviously no one turns their mind to the fact that Rule 56.5 is in fact slightly differently worded from from section 11 of the Act. So what I submit one gets out of that is this. This is not a case of, let us say, subsidiary legislation being passed very close to the Act and under the Act, when sometimes you might say you can look at the subsidiary legislation to understand what was in the mind of the maker of the primary legislation. It's clearly out of the question. What has happened is, and even in 2005, these rules aren't even passed under Section 24 of the Act. They don't purport to be. They're just passed under the civil proceeding rules. And the civil procedure rules, I think we have in the main, in volume 13, they, of course, do not provide any power in the Rules-Making Committee to pass rules which conflict with the statute. I think the rules in the main, not entirely sure where the rules are, in fact, but in the main bundle. But my lords, we refer to the rules in our case. The statute, section 77 of the Supreme Court Act. Sorry, forgive me, it's here. It's volume 13, page 5845. And it begins at 5846. You'll see section 77 provides for a rules-making committee to make rules of court. And then section 78 defines the powers of the rule-making committee in fairly standard terms. And we've quoted the only one which seems to matter, section 78(1)(a).
Then we have the contrast between the JR rules, which are brought in specifically under Section 24 of the JR Act, and this later one, which contains no reference to the JR Act at all. I mean, are you saying that that particular rule on delay was never effectively brought in?
Well, of course, 56.5 is only part of an entire raft of rules, and so they would have been brought in effectively. But my lords, I certainly say, however one approaches what you might call the other rules in the CPR now, the one thing I say that can be said for a certainty is that there is no intent, that you cannot say that Rule 56.5 in some way overrides or affects Section 11. There was simply no power in the Rules-Making Committee to do that, even if they had been acting under Section 24 of the Act, because all they can do under that is to give effect to the Act, not in some way contradict it or alter it. And they weren't made contemporaneous. So, my lords, I submit that the Court of Appeal in this case was plainly correct in its construction, and that construction, my lords, followed the construction given by the majority, at least, in the Devant Maharaj case, which you see at volume 13, at 5891. begins at 5891, at paragraph 19, 5896. This is in the judgment of Mrs. Justice of Appeal Smith, paragraph 19. Where Mr. Justice of Appeal Smith puts, so to speak, my submission for me in paragraph 19, and then he goes on to discuss the Absal Mohammed case, going on to paragraph 28. And likewise, Mr. Justice of Appeal Barreau, at paragraph 7 at page 5904. I submit is entirely correct. My Lords, if I can just briefly deal with some other points on delay and then go to my next point. My learned friend, Mr. Ramlogan, has said, well, what you might call the combination of 56.5 and Section 11 hasn't given rise to any problems in Trinidad and Tobago, to which my short answer is, well, it has. It's given rise to a conflict between two authorities. But more importantly, I submit judges simply cannot alter the meaning of a statute or say that the rules, if they're wrong in saying the rules have done so, then the court should say so. Secondly, my learned friend took you to the Friends of the Privy Council's decision in the Friends of the Fishermen of the Sea case, and I submit, my Lords, the points put to him in argument were entirely right. The board's decision proceeded on the basis that the underlying decision, which they were analysing, was one based on Section 11.1. At the same time, the judge and therefore the board also took into account other factors which arise under Section 11.2. And I submit that's the correct approach. I mean, if I can put it this way in simple terms, Section 11.1 and Section 11.2 are different sections, although there may be an overlap sometimes in the considerations which apply on both. My Lords, the next point, and I submit is a very important point in the context of this case, is the public interest point. And my Lords, we've recited in our written case the judgment of Mr. Justice Laws in the Greenpeace case, which you can see at volume 15 at E6633. If I can just ask you to read that paragraph again.
In your case?
It's in our case, but also if I can take you to the case itself, just in case. It's at volume 15.
Does that say anything different from what's in your case?
No, either is as good as the other. Just in case.
Your case paragraph.
36.
Thank you.
So it's 6639. I'm not sure actually it's got a paragraph number. The page number is 6639. Not quite sure what's happened to paragraph numbering on this, but it's right at the top of 6639.
Paragraph 12 of your case.
Paragraph 12 of our case, yes. Where Mr. Justice Laws says that questions of delay and the like apply with particular strictness in the context of public interest litigation, and he explains why. And in my submission, it is very important, the explanation he gives. And if I can just ask you to read that yourselves, briefly.
It's a rather limited view of the public interest, that.
Well, my Lord, but right, I say.
No, I'm not saying it's wrong, but it does seem to be the public interest here,
yes,
from your client's point of view, is getting a much-needed road built, at least one that they say
yes,
much needed.
yes.
It's not about giving a quietus to decisions which are not of any value. it's a quite different situation.
Well, yes.
That's why I was putting, I mean,
Yes.
good administration
Yes.
is a curious phrase, and in Caswell, Lord Gough was careful not to define it.
Yes.
But it would seem to me obvious, as a matter of common sense, that in a case like this, the public interest in a major project proceeding is an important factor, and detriment to that is an important factor to weigh in the balance
Yes.
against the very important factor of protection of the environment.
Well, yes. Well,
Mr.
I do
Justice Lord
submit,
wasn't dealing with
which is my case anyway, my lords, whether I'm right or wrong is another matter, but I do submit it is, this is correct. In other words, generally speaking, because there are no private rights which are being protected by the applicant, then the court is rather more stringent about whether or not this claim really is in the public interest. And I submit that it's, at least to that extent, it's a fair point.
I mean, it clearly is in the public interest. If you're proceeding in contravention of important environmental safeguards, that's a matter of public interest.
Well, my lords, I would accept that. I mean, if we are, and
Yes.
if we're doing so in the way that matters. But in any event, my lords, my submission is that the courts are more, partly to the problem of abuse as well, and indeed lack of undertaking in damages. My lords, of course, one wants to encourage actions in the public interest, but they are notoriously, or they can be, the means by which busybodies...
I mean, we get, the busybody cases, vexatious litigants. I mean, everyone accepts that these applicants are a serious body acting in the public interest.
Well,
the only question is whether they have a substantial case and whether the delay is outweighed by other factors.
and indeed whether they've got a case that ought to be coming on.
Yeah.
My lords, that's what I say about the law. As far as the facts are concerned, can I just make these points? First of all, there's a point I've made earlier, but it does lead on to another point I want to make, which I haven't made yet. There was, as I've said, no application for an extension of time and no evidence in support. The applicant just turned up on the basis I don't need one. My lord, that is important because it meant there was no call for us, respondents or the interested parties, to put in specific evidence of prejudice. For instance, let us say in the case of the ministry, the cost of complying with the conditions which had been attached to the certificate before the 29th of September, and so forth. Or indeed afterwards. But also, I'm told, there was no argument before Mr. Justice Ramcharan on the basis that absence of prejudice by the delay was a good reason for an extension. So it is not fair for my learned friend, as I think he was doing this morning, to criticise the judge on the basis he didn't take into account as a good reason absence of delay. That just wasn't the basis on which the case was put to him. One then looks at how Mr. Justice Ramcharan dealt with the matter, and my lords, I think you've seen it. He considers the chronology at pages 4797 to 4800. If you can take it to that. Volume 10.
Paragraph numbers, please.
I will find it. I don't seem to have the... It's 4797, it begins.
I know, I'm working from a different copy.
25.
Oh, sorry.
I found all the relevant judgments in volume 11, which was very convenient to me.
Oh, forgive me, my lord. I've been working from a different one. It starts at 25.
Thank you.
One can pick it up at 25. 26 explains, first of all, how Mr. Abood got hold of the documents, or how he found out, rather, about the making of the grant of the certificate, rather. And then paragraph 27, he deals with the chronology. No issue is taken on this. And then paragraph 28, he recites the submissions made by leading counsel for the appellant with regards to delay. Saying, and the submission was that there's no basis for claim of undue delay. And then the judge goes on to recite the submissions in 29. And the submission was essentially that because it was essentially that time didn't run until the 6th of July when the appellant found out about the order. Sorry, the issue of the certificate.
Yes, but 29, senior counsel also suggested, even if they're not within time, ample reasons.
Exactly. And he then goes on to, as I understand it, to recite what those reasons were.
I think we saw them, didn't we, in paragraph 25?
Sorry?
I think we saw them in paragraph 25.
Yes.
There's a quotation there from the application for leave.
Yes.
So that's what the claimant said about promptness.
And also, you find, my lords, 30 and paragraph 33. Public interest point was taken. In paragraph 34, the judge observes there's no application or any affidavit evidence.
And wasn't it a slightly technical point, that arguably? I mean, I was just looking at the grounds, paragraph, page 34 of the record, volume 1, sets out the reasons which are being put forward for delay if they needed to make that case.
Yes.
And they included, in addition to what the judge mentions, a list of the 6 things that they were doing, gathering information, assessing the circumstances, and so on.
Yes.
And wasn't that verified by affidavit in some form? And there were some affidavits.
Yes, well, but my lords, I wouldn't. I don't understand the judge to say because there was no affidavit, I'm not going to let you run the point. But my lords,
I mean, it's clear what the case they were making.
Yes,
You're
yes.
saying it didn't cover absence of prejudice.
exactly. That wasn't one of the. I mean, well, he's now been criticised for,
Yes.
in my estimation, something he wasn't asked to take into account.
Yes.
And my lords, I submit there was a reason for that, what you might call a tactical, perfectly understandable reason for that, and that is because they hadn't applied for an extension of time. So, of course, they know perfectly well that this issue of delay is not properly going to be before, or prejudice from delay is not properly going to be before the court, whereas it would have been had they made such an application. And that is why it's important to see how the case was run. So, my lords, I submit, when you look at how Mr. Justice Ramtran deals with the matter, I make 2 observations. First of all, he considers the matter in accordance with the way it was put to him. There's no error of law or fact. And his evaluation, because that's what it is not an unreasonable one. And it really has to be an unreasonable one, or one that no judge acting reasonably could have made. And I submit there's no basis for holding that. My lords, in our case, we recite well-known cases about evaluations and not interfering with evaluations.
We gave one this morning, remember?
Sorry?
We gave one this morning about the approach.
Well, I hadn't caught up.
I don't think it changes anything.
But my lords, I submit that's the question. Given the way it was put to the judge, has he really gone wrong or acted in a way which no reasonable judge could in saying there was no good reason to extend time? I submit not. It's a perfectly fair approach, and that really is the end of it. My lords, my learned friend has suggested that the decision was wrong because this is a complex case. Can I just make these points on that? First of all, the National Register not only records what is going on in relation to application, but you can go there and get hold of all the documents which are referred to in the National Register. And we know that in this case, if I can ask you to go to Bundle 9, we know the applicants did indeed go to get the documents, all the documents from the National Register on the 7th of July, only a few days after they'd become aware of it.
But not the technical officer's assessment.
No, not yet. But my lords, the vast, what we've got in about up to the end of 6th volume of the record. They've got all that by the 7th of July. And if I can give you the reference, it's at volume 9, page... volume 9, page 4227. Paragraph 8. Perhaps I should just take you to it. I'm being told I might be wrong.
Yes, you are.
No, you are.
Two are their photographs.
So,
It's a nice picture of trees.
forgive me. Yes, I think I have got a wrong reference. Well, perhaps I can come back to the reference, but certainly what my note says is by the 3rd of July, sorry, by the 7th of July, they have obtained all the relevant documents. And we know, when you look at their 7th of August letter, which is at volume 4 of the record, if I can just ask you to look at that, at 11:58. You can see the terms in which the appellant writes to the Minister of Planning. They write to complain. And over the page, of the second paragraph, they say the appellant has undertaken a review and assessment of the process by which the appellant granted approval on our examination of all the relevant documents, including, and then they go on to list what is including. So by this time, they have all the information that is needed to bring a claim. And then they write their pre-action protocol letter on the 12th of September. And that, of course, is a few days after they've been given the information, or the leaked information. That is at volume 6, page 2378. So,
And you reply on 20 September. You reasonably take 8 days,
yes.
but they've got to file within 48 hours.
Well, my lords, the short answer in my submission is this. It's a common problem, obviously, that one sometimes runs up against time limits when you're still going through the pre-action protocol process. What you do, and this is entirely normal, is you issue anyway and say, right, let's go through the pre-action protocol now that we've got some time. That's the proper way of doing it. And in my submission, that option was simply not followed. I might add this, given that they had thoroughly reviewed everything by the 7th of August, one might ask, well, why does it take so long to get the pre-action protocol letter out? I understand the point about the technical stuff coming in later, but that is not a reason to avoid getting all the other material out. And my lords, in this context, may I remind you that there are about, I can't remember, 16 or 24 grounds. The leaked information forms the basis of only part of the claim, and it's not a very big part of the claim, as originally put. So I do submit that there certainly is no good reason for the delay as such. I accept that doesn't answer the point about good reason for an extension. But really, one does wonder, why have you taken so long? And I submit the answer's just not there. You certainly could have done.
Is there something, authority, that the pre-action protocol doesn't justify setting back?
Yes, my lords, I don't think, certainly in Trinidad, as in England, as I understand the matter, there's a specific provision in the pre-action protocol saying this does not affect the running of time. We refer to that in our case.
Yes.
So, the other point, my learned friend refers to the importance of the case, but Mr. Justice Ramcharan himself recognises that at paragraph 38 of his judgment. My reference is volume 10, page 4803. And my lords, we do pray in aid of that. The appellant says this is a very important case. But what is rather remarkable is the appellant took no interest whatsoever in any of the public consultations at all. And there is a concern on this side, if I may respectfully say, that, so to speak, if you really are that concerned about what's going on, would you turn up to the public consultations? Rather, what you get in this case is someone comes in right at the end and upsets the process.
Has there been any explanation for that?
There is no explanation for that. And in all, I say all, but most of our affidavits, we specifically make the point, you didn't turn up to the public consultations. You didn't ask for the administrative record, as far as we're aware, and write in with objections. And there was extensive public consultation. There were two public consultations at a local primary school before the impact assessment was prepared. After that, then the administrative record goes up on the National Register and is available, I think, in 4 parts of Trinidad and Tobago. And all the relevant documents will be on it, including the impact assessment. But we hear nothing. And then after that, we have discussions with various other non-governmental organisations and interested parties, but not with the appellant, because the appellant doesn't turn up, doesn't express any interest in the matter. And I'm also told the EIA was on the EMA's website. I think that is in evidence too.
But it's covered in the statement of facts, I think, most of the points.
So we do say one has to regard with a degree of caution the protestations about public interest. This is all very a matter of the great public interest from someone who doesn't seem to have taken much interest in the course of it, in the natural progression of things before the grant of the certificate. I think finally on this point, my learned friend relies on the freedom of information request, but my lords, as we understand it, as I understand it at least, that what you might call the need to wait for the freedom of information request was not a reason put forward for the delay below. So my submission, that's a red herring. As far as delay and prejudice is concerned, as I said earlier, I will leave that to my learned friend Mr. Benjamin to deal with. But we submit, you will have read in the judgment of Mr. Justice of Appeal Smith, he deals with that at volume 10, 5122, paragraph 47, to 5124, paragraph 58.
Who's going to deal with the cumulative impacts?
I'm going to deal with cumulative impact, yes. But Mr. Benjamin will deal with the question of prejudice from delay on the facts. As far as ground 2 is concerned, I hope I can deal with that pretty quickly. If I can just ask you to turn that up, and I'll make my submissions, I hope, as swiftly as possible.
This is the TOR.
Volume 13. Yes, this is the TOR point. It's at... The rules begin at 5765, and the relevant rule is at 5.1 and 5.2. What I submit is the short point, is that my learned friend's arguments take no notice of the words in 5.2, where appropriate. It's only where appropriate, and I'll come on to what that might mean, that the applicant, in this case the ministry, has to conduct consultations.
Did you say, because somebody certainly did, that where appropriate was to be judged by the developer?
My lords, I think the judge, Mr. Justice Ramtran says, yes, that's in the purview of the developer rather than of the authority itself. And my lords, I submit so far as I need to that is correct. But I say on any footing, it doesn't really matter, because in this case, there was no requirement.
So where appropriate means where it regards it as appropriate.
Yes, and my lords, one has to look at the entire section. But what, if I can anticipate, what I submit this is directed towards is this situation. The authority says, I want you to do, the authority sets terms of reference, which let's say the developer thinks are pretty arduous. He thinks, well, it's going to cost me £1 million to do all that, and it's completely unnecessary. I want a much softer terms of reference. So I don't have to do, let's say, so much investigation into wildlife and so forth. Then there is obviously, he is not happy with his terms of reference. What section Rule 5.2 is doing is providing a process by which the developer can then go to, as well, consult with third parties with a view to getting them on board to say, yes, there is no need for such a swinging terms of reference. On the other hand, take this case where everyone's happy with the terms of reference, or rather the developer and the authorities happy with the terms of reference. I submit there's no call for and no need for any consultation whatsoever. So,
But your public consultation comes later anyway, doesn't it?
well, under the terms of reference, it did. But that's why I say, but my lords, that's my second submission. My primary submission is, even if it's a matter for the authority to decide and to dictate, in this case, the authority did not dictate that.
I thought the hypothesis would be, if you're wrong about your first submission, that ultimately, if there was an issue about it, it would be for the court to decide.
Well, I would accept that. Ultimately would probably have to be for the court
But
to
that's
decide.
your second point.
Yes.
Your first point is it's up to the developer.
No, my lords, if I can, I don't want to sound as if I'm avoiding your question. My first point is it doesn't matter, because on the facts of this case, there is no allegation as to why it would have been appropriate for there to be a consultation. In other words, no matter what the precise construction is, there's no fact or allegation advanced whatsoever to explain why, on the facts of this case, it would have been appropriate. That's what I call my overarching submission, which covers whatever the construction is. My second submission is, on the facts of this case, it would have been inappropriate in any event for there to be consultation by the ministry, and that is because the draft terms of reference themselves provided for public consultation in any event. So what's the point of having a public consultation on the draft terms of reference as well? I mean, how much public consultation do you want?
Well, one can go on with this.
Yes.
I could respond on that, but I don't think I will, because you've got other things to move on to.
Yes, exactly. But my lords, it's set out in our case.
Yes.
And we also say it is important that there's no suggestion of what is wrong with this terms of reference, and that is, in my submission, important. What's your complaint? Why would public consultation be even faintly appropriate? There's nothing. So it's, in my submission, an arid point. But there is another point which I would like to make, but we deal with it in our case, and that is the time point. This was on any footing a final decision as to what the draft TOR should be. What the TOR should be. There's nothing provisional about that. And in those circumstances, I submit that there is the time for challenging the TOR is 3 months from the date of the making of it. And that means 3 months from the 12th of December, which is the date it was made, and even with an extension of 8 days, the 20th of December. We're talking a very long time ago. The 20th of December was when it became public.
Yes, please carry on, Mr. Knox.
My lords, just on this point about when does time run in relation to Rule 5.2, there is a case which is in volume, I think it's volume 15, I think, with Nash, which distinguishes Burkitt. This is in relation to the award of a contract, or rather a decision to award a contract in a public procurement case. And I think I'm right in saying it's at volume, page 65, so it'll be 15, 6550. You can see the issue itself in paragraph 1. The applicant was aggrieved at a decision by Barnet London Borough Council to outsource certain work to the private sector. So they make their decision. The question arose, when should you brought our application? C says, well, I didn't have to bring my application until the actual award of a contract pursuant to that decision, to which the Court of Appeal said, no, that's wrong. But the important passage is at 6558, where the Court of Appeal sets out the reasoning of the judge at first instance, who was confusingly at that point the judgment of Underhill LJ, but they endorse what Underhill LJ says in paragraph 40, And then paragraph 41, they set out the first part of the judge's reasoning. And then paragraph 42, that we're now back in the Court of Appeal's paragraph numbering. The Court of Appeal go on to deal with the way the judge had dealt with Burkitt. Then finally, paragraph 64 and 65 make the point that this was not a provisional decision in the way that the conditional planning consent in Burkitt could be seen as a provisional decision, and therefore there was no reason to use the reasoning of Lord Steyne in Burkitt in this type of case. And I submit this is absolutely plumb for our case as well. It's exactly the same point. Nothing provisional about the decision to agree at all. It's final. And the reasoning in 64 and 65, I submit, applies quite naturally. My Lords, I've also referred to the case of Champion, which is in the same volume, I think, tab 20, sorry, I called it tab 6454, where my Lord Carnwath, in relation to a screening decision, said he would want to reserve his position in relation to how Burkitt really works in such a case. That's 6454. Sorry, 6454. Paragraph 63. In that case, this was obiter because no time point had been taken to the effect that time ran from the making of the screening decision rather than later, but it's paragraph 63. Lord Carnwath says he would wish to reserve his position about the position where a decision has been made, people, as here, have acted on the basis of it being a valid decision. And then a year or so later, 6 months or 9 months later, someone comes along and says, oh, no, you shouldn't have done all that. So, my Lords, that's what I say about 5.2. As far as cumulative impact assessment, my Lords, I just first of all to see how see the way the point was put at volume 1. At page 12, I seem to have lost my volume 1. It's at page 12, subparagraph 6 and 9. You can see how the point is put. So there, it's put rather generally.
12 of what?
Sorry, page 12 of volume 1. And it's subparagraphs 6 and 9 are the way the point is put.
Along the bottom here.
Oh, I see, sorry.
We accept that no cumulative impact assessment was provided in relation to the effect of the 5 kilometres taken together with the other 27. But the reason, my Lords, is volume 3, page 959. One can pick it up at 958. What you have at 958 and halfway down, analysis of environmental impacts, you have the comments of the authority,
What is this document?
This document is the response which my client prepares to the review and assessment report. And the way it's worked is that they have each of the individual complaints in the review and assessment reports, followed by a reply. And so the structure of this particular page, for instance, is on page 958, you have halfway down the page the authority's comments on the impact assessment, and then at the top of 959, you can see it's marked by little corners. At the top of 959, you have the response, which explains why the cumulative impact assessment wasn't provided. Exact details, location, design, etc., have not yet been finalised. They will be included in forthcoming discussions with the authority on package 2 and future phases. And then Mr. Romano explains why the authority accepted that at volume 7, 2949. Paragraph 78 to 83.
Sorry, give me the page again.
2949.
209. Paragraph 77.
It's 78 to 83, where he explains why the authority was prepared to accept that there didn't need to be an impact assessment.
Funnily enough, 77, I've read the affidavit of so-and-so, particularly his opinion that the ministry failed to assess the cumulative impacts. This statement is untrue, but the ministry had failed to assess the cumulative impacts.
No, my lords, only on this particular point. There's no doubt that there are plenty of other respects in which the cumulative impacts have been assessed. This is not the only cumulative impact that failed to be assessed. So in other words, the cumulative impacts had been assessed. The one assessment which hadn't been made was the effect of this 5 kilometres taken together with the other 27 kilometres. But for instance, the impact of any other cumulative impact assessments, it's all over the place, if I may say, in the impact assessment. So it's just this one aspect which wasn't assessed.
So essentially, you didn't know where the highway was, where exactly it was going to go, and
Yes.
and didn't want to carry out an impact assessment until you, or thought you couldn't until you knew where it was going to be located.
But, my lords, can I just ask you to look at the map, just so it becomes a little bit clearer? There are annexed to our case.
Are we dealing with phase 1 or phase 1 and 2 at this stage?
Well, my lords, I haven't had time to look at the maps which we were given this morning, but there were next to the respondent's case. There are maps annexed to the respondent's case, which should be in fairly big form.
Anyway, what are we talking about when we look at the cumulative impacts?
Well, if I can ask you to look at page 12, annexed to the respondent's case. I don't know if you have that. It's one of the annexures to the respondent's case. And this map here is the map on the register, National Register, which shows the entire proposed development.
Yes.
And what you can see, I hope, on this map is there are 3 phases. Phase 3 to the west, phase 2 to the southeast, and phase 1. And the relevant bit of phase 1, i.e. package 1, phase 1, is what you see marked strongly in brown. That's the 5 kilometres. That 5 kilometres, it is proposed, will connect up with a road which goes a little bit further east and then north and then back down south around Sangre Grande.
Which page you on? I've just found my volume.
12.
Thank you.
And so that's all future roads, is it?
That's all future work. And likewise...
Mr. Knox, in your case, you made it quite clear, that, as you've just said, that when we look at the eastern end, there needs to be a bit of work connecting it up with an existing road. What I don't think you did say, because perhaps you didn't understand it, was that at the west also there's a hiatus between the brown bit and the existing highway.
I accept that, my lords, and I apologise. In our case, we don't mention that
Very well.
it's 300 metres as opposed to 600. My lords, the measurements are 600 metres to the west, 300 metres to the east, and that, in fact, is as set out in the application for the certificate in the first place. And you will, which I'm afraid I hadn't spotted at the time, I should have done, but there's a small connecting road that will have to be made in any event. I accept that. But, my lords, the point I'm on at the moment is the connection. Now, what are we talking about when we're talking about cumulative impacts of the other parts of the highway? Now, in my submission, there are two. It's important to distinguish between two different things. One is the cumulative impact of the fact that other bits of the highway are going to be constructed later on, the mere fact of the construction. Now, that construction is going to be necessarily taking place away from the road, the 5 kilometres. It's not running parallel to, it's all running away from the road, and likewise up to the west, it's running away from the road. So the point I'm seeking to make is this: it's not irrational to say, well, I can't assess the cumulative impact. It's not irrational to say I don't need a cumulative impact assessment now of the construction of the rest of the road. As far as the construction of the rest of the road is concerned, it's obviously not going to have much of an impact on the 5 kilometres itself, which is all running away from the 5 kilometres.
I mean, surely, when you're looking at cumulative impacts, the degree at which you can assess will obviously depend on the degree of detail you've got.
Yes.
But that doesn't mean you can't carry out any assessment. And
No.
indeed, you signed up in the TOR to do a cumulative assessment.
Well,
so
my lords, we
what's
did.
changed?
Well, my lord, what changed was we asked. We said there would be difficulties in doing so because the design hadn't been completed. That's
But you knew
precisely
that
the
anyway.
case.
You knew exactly. Everything was known at the time you agreed the TOR, wasn't it?
Well, the fact is, when we were asked to provide a detailed cumulative impact assessment in relation to the highway taken as a whole, all 32 kilometres, we were asked by the ministry to forego that impact assessment. That's what it comes to. What I'm at the moment suggesting is it was understandable that impact assessment should have been foregone. First of all, the precise route would not be known. The reason
Well,
why
you say that, Mr. Knox, but could you look at your number 5 of the plans you've helpfully provided?
Yes.
Well, haven't we got the other phases on this plan?
Yes. No, we don't.
What do
this
we have
plan,
here?
On this plan, it stops at the west side of the 5 kilometres. In other words, what you don't have on the plan at 5 is what you see as described as phase 3 on plan 12.
So we got phase 2.
You have phase 2, exactly.
Why can't there be a cumulative impact referable to phase 2?
Well, my lords, the answer, what the ministry said to us was, we haven't yet we haven't worked out the precise location of where phase 2 is going to go. Now, what that means is the precise direction in which the road is going to take, and therefore how many people you're going to have to move, for instance, in order to carry that construction out, has yet to be worked out. Because, my lord, take phase 2, you'll see it's going to be going towards Sangre Grande, and there will be, or there may well be, considerations of compulsory purchase. Indeed, I think it's in the record as such. There will be considerations of precisely where will the phase 2 road go. But, my lord, in my submission, that the fundamental point is this. If I can go back to my distinction between cumulative impacts assessments of two different types. If one is simply looking at the building of the road, one asks, what great difference is going to be made by the building of the road to the east? The mere building, because the building of the road is going in a completely opposite direction. It's not going to be making much of a difference to the 5 kilometre stretch of road. And likewise with the road to the west. They're running away from the Repos Savannas.
Well, I don't understand why it's not still possible to say this is a much bigger road than 5 kilometres.
Yes.
Therefore, what travels along the 5 kilometres is going to be traffic coming from the far end to the other far end once it's all constructed. That's going to have more of an impact. I mean, I'm taking a really basic point.
No. As far as the use of the road, it's going to come on to the question of the use of the road.
Well, I'm trying to illustrate
Yes.
why you ought perhaps to look at the generality of the fact that this is going to be a 20-whatever kilometre highway.
Well, my lady, we did look at the generality in many respects. I mean, it's not the case that there was simply no assessment whatsoever provided as to what the state of the rest of the road was going to be, or indeed what that rest of the road would do. But can I take you to table 21? I mean, I was simply trying to distinguish between cumulative impact about the construction of the other bits of the road, which are not likely to have much impact, and then use of the road is very different, I accept that. And if you look at table 21 in... forgive me, I think it's volume 2. $397, thank you. Table 21 at 397, what you have is a table headed, you'll see, potential environmental risks and mitigation measures associated with the CHRE project. And there are a number here of references to what is going to happen elsewhere on the road as it's built. I mean, there's some obvious examples. For instance, if you go to page 403, you'll see under the comments section in the main box, potential disruption to the free passage of through traffic in existing roads is likely to occur during construction of the underpasses, overpasses and interchanges, apart from community number 2 and Eastern Main. Our Eastern Main Road is well to the east, and so forth. And there are a large number, as well, over the page, for instance, perhaps a more obvious one, a shorter one, page 404, in the comments as well, the second box down, is a reference to the nature of the soil south of Sangre Grande. South of Sangre Grande. Now, that's nothing to do with the 5 kilometres. And there are a large number, which one can see quite plainly. Let's say 407, the fourth box down, again, is to do with a different part of the road, not just the 5 kilometres. But there are a large number of comments here, which are nothing to do with this. And I think in our response to the review and assessment report, we did actually explain what's said here. We said in terms, we haven't just provided information about the 5 kilometres in question. We provided information about the entire project in this respect. But, my lords, in my submission, the question is can it be said that my client was unreasonable to forego the cumulative impact assessment?
I mean, your client had said, in the terms of reference, we must have a cumulative... Sorry, Mr. Knowles. I'll wait for you to get what you want.
No. I think for the moment I can come back to it. My lords,
Your client had said, in the terms of reference, we really must have a cumulative impact assessment on this. And when the first EIA came through, RAR, May, no, not nearly good enough.
Yes.
If that was a line properly to be taken in December and May, why was it a line not popular, that shouldn't have continued to be taken in June?
Well, also they changed their minds. Well, I accept your point, Will. It was put to them that this was simply not practicable. And they're left with that. My clients are left with that dilemma. It's not practicable because we haven't worked out the precise design as to where the other parts of the road are going to be going. So we don't know exactly. For instance, we don't know let's say, take the parts of the road which join the 5 kilometres. We're not exactly sure how that is going to be joined up. And therefore, how many other people, how are we going to deal with the particular interchanges or intersections? We don't know. And so in those circumstances, my Lord, we are asked to forego the cumulative impact assessment. The question in my submission is not, have we changed our minds, but was it irrational to change our minds, given the explanation we were given? And in my submission...
Yeah, this turns on what Mr. Romano says at page 2949. You say
Yes.
the question is, was that irrational in a Wednesbury sense?
Exactly. And also, my Lords, Mr. Agard's evidence at volume 8, 3997, 18, paragraph 18. Where he draws the distinction which I was trying to draw, which is the difference between cumulative impact relating to construction and cumulative impact essentially relating to use.
Is that an important distinction?
Well, in my submission it is, because if one... the reason I say it is because the whole premise of the environmental impact assessment is that the road is going to be used. And what the effect of my clients agreeing to forego the requirement of a cumulative impact assessment was that we don't need a cumulative impact assessment which takes into account the construction, the actual construction of the bits going to the east and the bits going to the west.
So, from this document we're looking at the moment, it looks as though cumulative impact was understood, at least by the writer, as meaning cumulative impact on phase 1 and on this protected Arepo savanna, yes, rather than the cumulative impact of the entire road on the environment of Trinidad.
Yes. Well, my lord, that might be right, but in any event, my submission still stands. It's not irrational to say you're not in a position to give me a cumulative impact assessment as to how the construction of the extended parts of the road on either side is going to affect the savannas. That's because it's difficult to see how it will, because they're going in a completely different direction. That, in my submission, is a short point. I've also had my attention drawn to volume 3 at page 960.
At page?
960, which I think is part of the response to the RAR. It's part of our response, yes. Part of the Ministry's response, forgive me. And halfway down, you'll see a reference as to how we prepared the EIA report for Package 1. Not all of the impacts in 2008 were considered to be significant for 2 reasons, and the 2 reasons are then given. Table 21, which is the table I was taking you to, includes the potential risks associated with all proposed phases, and only risks associated with Package 1 are considered in the assessment. And we go on to say we were told to be concise. I hope I can deal with the other points very briefly. I'm conscious of the time.
If the judge got it wrong on what he thought phase 1 consisted of, as he may well have done, because he thought it wasn't a road to nowhere, where does that leave us?
Well, my lords, I hope to persuade you he was not wrong to say it's a road to nowhere. because it is a road. There will have to be short connecting, 300 metres on one and 600 metres on the other side. There will have to be short connecting roads. But in my submission, there's no suggestion, there's no attack on the basis that those connecting roads are never going to get permission. And I do make what you might call the more general point on the, what you might call the road to nowhere point. That it is not part of the case against us, nor is there any evidence to the effect that it is highly unlikely, or indeed unlikely, that permission for the rest of the road will be granted. And I submit that's the fundamental point in the case. If there had been some such allegation, then of course we would be in trouble. But the position is, and I submit the board, the authority was entitled to take the view, that it was not unlikely that permission would be granted, all the relevant consents would be obtained for the rest of the road.
Sorry, you mean the rest of the whole project?
Sorry, rest of the whole project. And therefore there was nothing irrational in granting permission for the 5 kilometres on their own, because in due course they will be used together with the rest of the road. But further, even taken on their own, they do connect up 2 parts of the inland of Trinidad and Tobago. And I think, my lord, that was the point being made by Mr. Justice Ramjaran. It's not entirely irrational because this road connects 2 parts in any event. Guayco on the east and I think it's Kumutu on the west. And in my submission, there's nothing wrong with that finding. I accept he's ignored what we might call the 300 metres on one side and the 600 metres on the other. But, my lords, it wasn't suggested that that was going to cause any serious problems.
Yeah, in a way, you can't really have it both ways. So, I mean, if those weren't going to get built, there's no cumulative impact.
Well, that's why I say it's a sort of paradoxical attack in one sense. But I submit the real burden, and I do submit, my lords, that the whole burden of this case is much more the construction point. It's the construction of the road that's going to do the real damage, as opposed to or might do the real damage, as opposed to the use by motor cars later. But, for instance, things like whether squatters and so forth would be on the road and things like that, my lords, those things were considered. And others, the consequences of the use of the road as such were considered in the impact assessment. So, my lords, you have my submission. My lords, briefly in relation to the 4th ground, irrationality, my lords, I submit there's simply nothing in the point. Again, one has to look at how the claim is put against us at volume 1, 10 to 12, page 12, paragraphs 10 to 12. And it's put in entirely general terms. Essentially, the EIA was defective. That's what it comes down to. But the important point is there's no particularisation as to why it was, or indeed what followed from it. My lords, I've referred to paragraphs 10 to 12. But when you look at the affidavit of Mr. Abood, which starts at page 38 onwards, there's nothing that tells you what is there in the EIA, in the revised, what is it about the revised EIA that makes it unsatisfactory? And the only points, my lord, that appear to be taken in other witnesses are that the revised EIA doesn't contain baseline studies. That's really the only point. And if I can ask you to go to volume 6, page 2415, paragraph 27, is the first reference. This is the first complaint made about the EIA. What's wrong with it?
2145.
2415.
Thank you.
Volume 6. And the other reference in the same bundle is at 2884, paragraphs 9 and 11. Again, it's lack of specific baseline studies in relation to biological data. And Scott. He's only got another
Mr. Knox, we're anxious not to have a repeat of this morning, where Mr. Benjamin finds himself in the position that Mr. Ward was in.
Yes. The point I'm seeking to make is the only attack made on the revised EIA was the lack of baseline studies. Now, I submit it's not open, therefore, so to speak, now to expand it and say, right, well, you can now look at something wider. And what I say simply is the law, and that I can set it out, I hope, very quickly, is if you go to the Act, the main Act, at Volume 13, 5801 to 2. I think you've seen this before. Can I just summarise, therefore, what my submissions come to? Sections 28(1) to 3 set out the nature of the public consultation that is required. All that has to go up on the administrative record is a general description of the plan, and it's for the EMA to set out the length of time for the public comment. In other words, it's quite discretionary. And all that has to go up in relation to the impact assessments is the major environmental impact assessments. In other words, it doesn't provide for what you might call an extensive public consultation on all the details and so on and so forth. It's just the major environmental impact assessments. And it's entirely, and it has to be sufficient to give the public, quote, a reasonable understanding of the position. And further, it is for the EMA to decide not only the length of time for public comment, but whether to hold a public hearing. That's again in section 28.3. And if an impact assessment is required, then this too must go up in the administrative record. That's as far as it goes. The point I'm seeking to make is section 28 sets out the parameters of public consultation, and it gives the authority quite a wide discretion. Section 30, I submit, is important because what it is, which my Lord Carnworth drew attention to, because even though there's no such thing as a commission at the moment, what it does show is the mindset of the draftsman of the legislation. He is envisaging an express right of appeal for certain types of, quote, interested party. That's to say, people who have objected in writing. Now, there is nothing, however, which in the Act says there has to be a final or a complete impact assessment with all details prepared either at or after the public consultation phase. And in my submission, it is not the intention of the Act to give a wide-ranging right of appeal to the public on the basis they haven't been consulted. The next point is section 36. It is in my submission clear that the purpose of the Act is to enable changes to be made by the authority to what the developer is to do. In other words, you have this period of consultation. After that, it's obviously the intention that alterations will be made, or that there will be a period of public consultation, and the developer will have to answer the points that are put to him. So in other words, the process which we had in this case of the review and assessment report, followed by comment by the developer, is entirely natural. And again, in my submission, it follows that it's perfectly open to the authority to impose conditions on a certificate in the light of the further discussions between the developer and the authority after the public comment period is closed. That's the structure of the Act. And there's nothing wrong, therefore, with the authority imposing conditions as a requirement. It is true those conditions will not be subject to public comment. They will go up on the National Register as the conditions to which the certificate has been granted. But in my submission, that is what is provided for the Act. And as far as the law is concerned, my lords, I haven't taken you to this, but I have quite a bit more to go through, but I hope I can cut it short. In relation to environmental impact assessments, there is authority on what you need for there to be a good environmental, or rather what the appellant, in this case, needs to show in order to challenge the impact assessment. And what he has to show in my submission, it's set out in Bakongo number 2. It's a very high test indeed. And the mere fact that the impact assessment doesn't cover everything, or there are defects in it, and so on and so forth, doesn't matter. And my lords, I hope I can be forgiven just for taking to briefly one authority, and that's the judgment of Lord Hoffman.
I really wonder, Mr. Knox. Mr. Benjamin is going to end up with no time at this rate.
Okay, well, my lord, yes.
We can read it. Which judgment? Which case is this?
It's
Congo number 2.
Bakongo number 2.
Right.
We know that.
And it's about environmental impact assessments.
We know
and it's a very high
And
test.
it's fairly, well, I think it's a fairly controversial judgment. So let's...
Well, it was 3-2. But in my submission, that's the law. In my submission,
in Belize, yes.
in Belize, and, but also, given the nature of the act in this case, it is the law. It should be held to be the law in Trinidad.
Yes. Thank you very much, Mr. Knox. Well, Mr. Benjamin, you've been waiting very patiently.
Yes, I'm going to say that I have 5 minutes.
Yeah.
I'm going to go a little bit, and I apologize. I'm not even going to ask for the lecture.
Yes.
So, Lord, number 1, part 56 of the CPR provided to my lords. Can I simply let you know that? I'll ask those versus to get these authorities to do that.
Thank you very much.
That's all right. But I wanted to make it that my lord read that you had it. If
Yes.
you could ask about it.
Yes, thank you.
My lord, number 2, by way of housekeeping, can I simply say to you, a question was asked, or there was an exchange in relation to regional corporation approval by my learned friend, Mr. Ram Logan. In our affidavit, and it's to be found at paragraph 29, volume 9, page 4111, that's 4,111, we say overtly that all approvals were in place, all statutory approvals. Did we annex the regional corporation? No, we did not. If you want to know the date, I've taken instructions over the short adjournment. The regional corporation approval was provided on the 5th of January 2018. My lord, thirdly, can I make a quick comment about the Canara report, simply to invite my lord's attention to the fact that at volume 6, page 2459, you will see the words that the recommendation, and I quote, does not have any legal designation. Can I say that again? The recommendation for the 500-meter buffer zone in that report does not have any legal designation. And if I can leave it there without making any further comment on it. My lord, to the extent that I'm going to ask you to turn up any parts of the record, can I ask you first of all, in relation to what I might call the core argument of prejudice, invite your attention to volume 9 of the record, if you have it to hand.
Page?
I'm going to invite my lords first of all to page 4336. Can I say that again? 4336. And before I ask you to look at that, I'm going to make a very simple single sentence point, which is to say that on the 5th of October 2017 and on the 2nd of November 2017, what the learned judge was doing was exercising his case management powers. He was trying to get the claimant or the applicant or the appellant in this case to get a move on. In other words, there was before him at that stage no application for interim relief. You know from the record it wasn't filed until January of 2018. But he tried his best to chivvy them along. You will see his first attempt, unsuccessful in the event, at the bottom of that page. And does my lord see at the bottom of the page, 4336, the words court. Miss Partap, well, would you give, if I fix the application for leave, the hearing of the application for leave and the application for interim relief around 3 weeks from now, would that be sufficient time for you all to retain and properly brief counsel in the matter? And my Lord sees the rest of the exchange. So it's quite clear what the judge is doing is, even though no application has been filed, he's suggesting fixing a time for it to be heard. And that invitation, as you know, was not accepted in the sense that the appellant took no action. And then similarly, over the page, and I'm sorry for doing it at such speed, pages 4348, which is the second attempt at case management in trying to get the appellant to do that which he was hinting at. My lords will see, again, the court, so I'm taking myself out of it. I know what our contribution was put in the case and so on, but it's what the court decides that matters. My lord sees it there. My lord, can I just ask you can I just read a couple of the sentences to you? Make sure I have the right reference. Yes. Intended respondent and interested party to file and serve affidavits in opposition to the application for leave. Next sentence, affidavit in reply. Important sentence. Any application to be dealt with by the court to be filed and served on or before the 16th of November 2017. So here there is the learned judge on the second occasion, that is to say on the 2nd of November, saying, well, okay, you didn't file it within 3 weeks of the last occasion, or whether it was 4 weeks, it doesn't matter. On this occasion, I will give you a firm timeline. And we know, as the events turned out, that no application, in fact, was filed. And then my sort of final reference, if I could just invite my lord's attention to it, before I make my submissions on that material as relation to prejudice. Can I invite my lord's attention to volume 7? And ask you to look at page 3451. And what my lord will see there, 3451, and what my lord will see there is the public notice that was published to all the world on the 1st of December. My lord, I apologize, the quality of the print is poor, but you can just make out in the very top right-hand corner that it was published on the 1st of December, and in that notice, my lord sees it in the fourth line, that the expected commencement date was the 2nd of January 2018. So here was the whole world being told, and it's just as an important element in the chronology, the ministry's affidavit wasn't filed until a week later on the 8th of December. And so this notice is exhibited to that affidavit, and so that's the context in which to see the email exchanges that took place between the parties. Because we get to the 22nd of December, and my lord, so we've been in the case for 2.5 months. We're expecting that somebody's going to file an application, and that doesn't happen. So it's against that background that we interpret the inaction of the claimant as to be at least a disinterest, so that we have the exchange, we say to them, the one thing we're waiting for is regional cooperation. We've already told you when we're going to start. We could not start on the 2nd. Regional cooperation doesn't come into being on the 5th. The following Monday is the 8th, and that's when the work starts. So broadly speaking, can I divide, in the next couple of sentences, issues of prejudice? So you've got pre-filing prejudice. In other words, prejudice to us, on the one hand, prior to the filing of the application for judicial review. My lords can see from the chronology, and I'm not going to take you to it, that we have begun to take steps to comply with the conditions as soon as the CEC is in our hands. My lords will see, as you go through, we retain a consultant to do the baseline studies. That happens in August. And, much more importantly, that fact is to be found on the National Register, so that we are incurring expenditure, letting the whole world know what we're doing by way of fulfilling conditions, and nothing is happening by way of the filing of an application. And that continues all the way down to September. Now, what is said against me after the filing of the application is that, well, you know, we wrote to you, we filed an application, you have spent this money, as it were, quote unquote, at your own risk. Well, my Lord Conworth has made it very clear, this is not a commercial project. This is a project aimed at providing an improvement in the living standards and conditions of the poorest part of the country. That's in our written case, and I won't take you to it. So that we make a judgment based on two separate things. I've already taken you through the chronology. I won't repeat anything I've already said. But we looked at the application for judicial review, and rightly or wrongly, came to the firm conclusion that it could not go anywhere. And we said that to the judge. Not once, we said it twice. It was said on the 5th of October, we intend to oppose leave, and the basis for that determination was that we thought that the grounds were not sound. And we repeated that position on the 2nd of November. So our judgment was that the application was not soundly based, it wasn't firm. Whatever the standard that you apply, whether it's Sharma and Antwine, or whether it's a more rigorous standard because of the interlocutory relief that they sought, and it was against those circumstances, weighing that up against the purpose of the project, which is to provide within a very short time frame, because I'd ask my lords and my lady to bear in mind, this project was intended to be of 10 months duration. Had it started in January, it would have been completed in November. We were trying our very best to take advantage of the dry season, which runs for the first 6 months of the year. My lord, everything I've just said is in our written case. The hurricane season is upon us, and, well, my lord knows that there are adverse consequences to the public interest. So putting aside prejudice to the contractor, putting aside prejudice to the Ministry of Works, what we say, my lord Carnworth, in answer to the question as to detriment to public administration, is the adverse impact on the very region that this project was intended to benefit. I apologize for the speed. Those are my
Not at all. That's been very helpful. Thank you very much, Mr. Benjamin. And you can take it. We'll study. You've given us a very clear case, and we'll study that with care.
Thank you very much, my lord.
Yes, Mr. Ward.
My lord, I'll just pick up on the prejudice point very briefly. There is a conceptual difference between proceeding with the discharge of conditions pre and post a judicial review challenge being commenced. And this clearly is post the commencement of the JR. I'll leave it at that. There's been focus placed by my learned friend Mr. Knox on the scope of the appeal that we bring now and the previous scope before Mr. Justice Ramcharan. We looked at the pleadings that were before him, and they're at volume 112. 2 points arising out of those pleadings. First of all, albeit I suspect I rather incur the wrath of my Lord Carnworth this morning when I started in with the third EIA, but with great respect, that is an expression of the allegation that was made all the way back at the hearing in front of Mr. Justice Ramcharan, failed to take account of numerous defects in the EIA, acted unreasonably in relying upon a defective EIA. We know it's defective, and it's not just the baseline studies that we criticise. My learned friend Mr. Knox is not correct in limiting it in that way. We know it is defective because we look at the schedule that is at the beginning of the third EIA, and I wonder if my lords and my lady would turn to that. It's volume 4.
Have we looked at this before?
No, we haven't looked at it yet.
It's too late. We'll note the reference, but we're not going to start looking at new documents that apply.
The point is, my lord, that it's a 24-page table. It's a schedule of the changes that were made between EIA 2 and 3. Despite the response provided by NIDCO to the RAR, a number of very significant changes were made between the second and the third EIA, some of them fundamental in their nature. And that, in my submission, is evidence enough to show that the earlier EIA, upon which the EMA relied, was defective. Baseline studies is an example of that, but it's not the only example. In terms of connectivity, my lords, my lady, volume 7 we looked at briefly. There are various other references of the minutes of the meetings with the public, where the public were told in no uncertain terms that there would not be any immediate connectivity. Of course it is accepted that no one intended that there be a 5,000-metre stretch of motorway in the forest for no purpose and with no connection. Of course it is understood, as Mr. Justice Ramcharan himself understood, that at some point in the future there would be connections. He mistook it as being that there would be immediate connection. And that is the critical difference, because the basis of his paragraph 95 of his judgment is that there was some form of immediate connection. And it's very clear from the references at 7, 3158, 9 and 3172, where we see exchanges between concerned members of the public asking directly, will there be connection? And the answers that they're given is no, not immediately. We'll consider how to connect in phases 2 and 3. It can't be assumed that those permissions will be granted, that CECs will be secured. Even if it is likely, the basis of Mr. Justice Ramcharan's paragraph 95 is flawed. Then, in terms of the design and the level of detail that is known more generally, the interested party has known in very considerable detail the entirety of the scheme since about 10 years ago. We know this from the Canary report. 62453 reveals that they had design work undertaken a decade ago. And in the interim period, the known detail has only increased.
Sorry, 624.
Volume 6, 2453.
Thank you.
It was, of course, a requirement of the TOR signed up to by the interested party that they would provide the necessary detail to undertake cumulative impact assessments. And we say it was there in spades. But to the extent that it was missing, with great respect, the appellant cannot accept the explanation that having agreed it at the TOR, having agreed it at the interim stages, the ministry was entitled to simply come back and say, sorry, but we don't have enough detail in order to undertake any form of cumulative impact assessment. And if I can respectfully adopt what is my Lord Carnworth's enunciation of the, if I may say so, rather obvious principle, one does a cumulative impact assessment to the degree that is possible on the available evidence. There is no requirement for perfection. My learned friend Mr. Knox relies on dicta to that effect. None of that was expected, but what we have is a binary situation here, where no form of cumulative impact assessment was conducted at all, and that, in our submission, is unacceptable. Then, so far as Rule 5 is concerned, both Mr. Justice Ramcharan and the Court of Appeal dismissed the argument that the appellant, the appellant was out of time to challenge the TOR consultation point. And the references for that are 10, 480031, judgment of Mr. Justice Ramcharan, where he concludes that time runs from the date of the grant of the CEC and not before, and that applies to all grounds, including the TOR Rule 5 ground. Secondly, Justice of Appeal Smith at 11/5118/29 makes the same finding in more explicit terms. Both of them on the basis of Burkitt dismiss the argument that one has to act immediately upon knowledge that one has been excluded from the pre-TOR process. There is an obvious reason for that. The facts of our case are stronger still than those of Burkitt. In Burkitt, there was a resolution to grant and then eventually a grant. Here, anyone who cared to engage in the exercise that my learned friend Mr. Knox says was possible, looking on the National Register, inspecting the underlying documents, would have seen evidence on the basis of which one could reasonably have concluded that there was no way that a CEC would have been granted in those circumstances. Numerous instances of deficiencies tabled in RARs, insistence that the terms of the TOR be complied with. So if one were in the sort of Burkitt situation of wondering whether to devote precious and limited resources to litigation now or wait and see until it was necessary, we are well within the territory of the latter of those two circumstances. For a number of reasons, including that the likelihood was, of course we know that that didn't happen, that the EMA, given the stance it was adopting, giving its insistence on strict adherence to the TOR, would simply refuse the CEC or would exercise its powers to defer determination of it until they had the necessary information that they sought. We do not know whether they were satisfied with the third EIA, because no further exercise was conducted in relation to it. Of course not. It came 2 months after the grant of the CEC. But what we do know from the table at its beginning, And I would urge your lords and your lady, if you have a spare 5 minutes, it will take no longer than 5 minutes. And I suspect many of you will not have a spare 5 minutes, but I hope that you do, and I hope that it is possible to look at that schedule and to consider whether or not it's considered that it is impermissible to raise a new ground. It's not a new ground. We've always, the opponent has always argued that the EIA relied upon was defective, and the quickest way to understand the numerous ways in which it is defective is to inspect that schedule. Some of the observations in it are not fundamental.
What's the reference to it again?
It's volume 4.
Yes.
It starts at 1162. It's a 24-page schedule.
What is it?
It's called Table Summarising the Changes Made to EIA Report on the Basis of the Review and Assessment Report. It comes after NIDCO's response to the RAR, which my learned friend Mr. Knox took you to.
But it is a NIDCO document, is it?
It is a NIDCO ministry document because it is the third EIA, which the public never had an opportunity to consider.
Thank you.
And finally, on that point, the third EIA...
You're going to have to make it a final point altogether. I'm afraid that we certainly have 5 minutes, but I'm afraid you don't.
I'm pleased to hear that, my lord. In that case, in the remaining 1 minute... The point made about the formal application to extend time, the Court of Appeal and the Court at First Instance proceeded upon the basis of an oral application to extend time. That is quite clear from their judgments, and it is expressed explicitly.
I mean, you don't need to deal with this point. I mean,
we don't need to deal with that point. In that case, my lord, I won't try the patience of the board. Instead, I will thank you for the indulgence given.
Thank you very much. Well, we're grateful to all counsel. What we'll do is we'll adjourn and have a short discussion to see if we think we might be able to give you a decision today, and we'll communicate that to you if you can remain available. And if we think we're going to be able to, we may take some rather longer time and then come back with a decision. And if not, we'll let you know. We appreciate that it might have been helpful to the parties to have a decision today if that were possible, but it's quite evident that we're going to need to take some considerable time to consider our judgment. So that is what we will do, and parties will be advised in the usual way when our judgment is ready. The court will adjourn.